Thanks, guys. All right. Good morning, everybody. Thank you for being here. We obviously come here today with a heavy heart to announce that on behalf of Joe Suave and Craig Schilling, the co-personal representatives for the estate of their son, Justin Schilling, that they are joining the lawsuit that has already been filed in the Oakland County Circuit Court. So we, what's called, amended our complaint, our lawsuit in Oakland County, and now these folks are a part of that case, as well as the family on behalf of another young lady who was in one of the rooms. We've also, that was filed this morning. We filed late last night / early this morning a federal lawsuit that names all of the clients, the folks that were already in the state court proceedings, but now, as well as on behalf of Jill and Craig, they're joining in a federal lawsuit that solely asserts what we call federal claims, and that's obviously in the United States District Court. We drew Judge Judy Levy, L-E-V-Y. She's a phenomenal judge. We're very blessed to have her, much like we are blessed to have Judge Chabot in Oakland County, and we will be proceeding along those lines. We have copies. You guys know how to get on Pacer and so forth, but we have the availability of both our second amended complaint in Oakland County, if you want it, and we also have the complaint in federal court. In federal court, just so you all know, the major differences are we're not asserting or reasserting the same claims that we are in the Michigan State Court. In the Michigan State Court in Oakland County, we're solely raising Michigan law claims, which sadly are a part of governmental immunity. You all have heard me drone on that before. I won't bore you again with all that, but the thing that you need to know on behalf of Jill and Craig and their family is governmental immunity shields what we believe to be those who are already guilty. It protects them from being held accountable like it does any other citizen. And so on behalf of Jill and Craig, I reiterate what we've already said in the past, and that is governmental immunity is unfair. It gives an unfair advantage to the government. It makes special rules for the government that the ordinary citizens don't have, and it should be abolished. And that's one of many claims that we've already brought in front of Judge Chabot. As part of our claims in the federal court, the allegations are, and what we will prove more importantly, are that as a result of the program, if you will, that the school had. In state court, you all remember we couldn't sue Oxford Community Schools because of governmental immunity. We can't sue them directly. And then when we do sue the employees, such as teachers, counselors, and the dean of students or associate dean of students, we have to allege and prove gross negligence as opposed to straight negligence, which is a higher burden. And we have to prove that they were one of the last causes. It's called the THE proximate cause. Higher burdens of proof, which again are unfair to normal folks. And if this very thing happened in a private school, that those higher proofs would not have to happen, that we would not be required to prove them. So that's unfair. But in the federal court, what we're alleging and we will prove is that as a result of the program, in particular, a suicide prevention program that the Oxford Community Schools had in place at the time. And I've got it for you. If you want it, you can have it. But what's going to be important that we show is as a part of the program that Oxford Community Schools had in place. A document entitled suicide intervention process. You can see the date is March 1, 2001. And what this does is it sets forth a process that the school has put in place to assess someone like Ethan Crumley, who they believe may need intervention to prevent suicide. What you also need to know is, in addition to suicide prevention, that when some child or some person has suicidal ideations, the line between suicide and homicide is often a very thin one. So you can't just think, I'm trying to prevent suicide. You need to see, does this person pose a threat or herself, threat to him or herself, or anybody else? And what you're going to see on this is where if the staff members encounters a situation in which a student appears to be contemplating suicide, the following process should be followed carefully. Well, you all remember Hopkins at the preliminary examination of Mr. and Mrs. Crumley testified that after he saw Ethan, interviewed Ethan, and then even spoke to both mom and dad while they were in the office, his conclusion was that Ethan was suicidal. So therefore, 911 should have been called, actually, and he should have had a psychiatric intervention. Translation, he should have been taken to an emergency room or to a psychiatric, inpatient psychiatric facility to be evaluated by a psychiatrist. All right, is it on? Hello? Okay. So under suicide intervention, what you'll see is how to stabilize the situation. And you got to find out under B, converse with the student immediately and determine if he or she has any dangerous instrumentalities, weapon, substance, or other capable of inflicting mortal wound on or near his or her person. Backpack. Backpack. And remember what happened after this intervention. As opposed to doing this very thing, they gave him the backpack without searching, which we now know had the gun, ammunition, and, if you will, the manifesto, the 30-some page document where he outlined his entire plan. Had they done and followed their step one, this mass murder would have been prevented, and these folks wouldn't be up here having to talk about the death of their son, who should have graduated on last Thursday. And they can address an award that he got that's amazing. It's basically what I call Senior of the Year, and I want you folks, you can share that with them. I know you're very proud of that. And you all are going to ask, and I don't want you asking them, but one of many things that you learn when doing what I do, your clients dictate when they're ready. How can you ever be ready for this lawsuit? And so these folks, Joe Suave and Craig Schilling, I applaud them. They took their time and they wanted to get through their graduation day. So we did that, and I applaud you guys for doing that. Thank you. When you move on through, if a student will allow immediately remove dangerous instrumentalities, well, imagine if you didn't allow that, right? So you search him and you make sure he doesn't have any dangerous weapons. If the student will agree, accompany him or him to a prearranged, non-threatening place away from other students. Guess where they took him? They sent him to class. They sent him to class, not away from other students or other people where there is another adult and a telephone close by. If the principal can be notified without leaving the student, to do so as quickly as possible. If the student will not agree, then they need to remain with him there. They never called the principal. They never called the liaison officer. So step 2 is assess the risk. And then you'll look down and you'll see further down in terms of severe risk and so forth. It's very interesting. I'm gonna skip now to severe risk procedure on the bottom here of the first page. And under severe risk, it says, paragraph 1, determine if the student's distress is the result of parental abuse, neglect, or exploitation. And if you all recall at all, as part of the allegations in the state law case, we've alleged that the school, the various personnel, but at this particular time, Hopkins and EJAC, violated and broke
the Child Protection Act. These are the words of abuse, neglect, or exploitation. So what you have Hopkins testifying at the preliminary exam, as you may recall, that when Ethan walked in, when Crumley walked in the room and his parents saw him, he did not stand up and hug them. They did not come over and hug him or greet him in any way. And that is a telltale sign that something really bad's going on. Their own policy says that. And what they're supposed to do then under the law, this is going to be part, again, of the federal claim. That's why I'm walking you through this. If so, in other words, if the student's distress is a result of parental abuse, neglect, or exploitation, if so, notify the Family Independence Agency. Translation, I need you to report this to under the Child Protection Act, the Family Independent Agency, or we say CPS. Give them the facts, request them to intervene and follow their instructions. If not, call the Oakland County Mental Health Services immediately, give them the facts, request them to intervene and follow their instructions. If neither agency will intervene by the end of the school day, call an emergency squad. Well, folks, I got news for you. Emergency squad should have been called before any of that happened. The Child Protection Act Michigan Compiled Law 722-623. This is the section that refers to a professional counsel, social worker, school administrator, school counselor, teacher, and other folks as being a mandatory reporter. And under this law, which I read to you last time, remember, if they have reason to suspect child abuse or neglect, just like it says on the suicide intervention process, they must report, and then the authorities figure out what's going on. Here, I wanted to remind you where it says under about halfway down this paragraph, if the reporting person is a member of the staff, and then it talk about hospital agency or school, the reporting person shall notify the person in charge of the written or electronic report available to the person in charge. In other words, principal, or if you will, even make sure you file your own report. But this is the most important part of this. A notification to the person in charge of a school does not relieve the member of the staff of the school of the obligation of reporting to the department as required by this section. Translation, teacher, school administrator, school counselor, social worker. If you have reasonable cause to suspect, even if you do some type of internal assessment, you must report this to the authorities, in particular Child Protective Services, and file what we call a Form 3200 and report suspected child abuse. And what we're going to find and what you'll see as this case goes on, the school and the school folks like Hopkins and the others are going to defend themselves and say, we were told not to report this. We were told that if we just followed our own guidelines, that's good enough. And so that's part of our federal lawsuit, that this state agency, if you will, deprived our clients of the constitutional rights, if you will, of due process of law. And therefore, in essence, trained them and told them. If they didn't train them, they actually made it clear, you don't have to call CPS and all that. We'll take care of it. Just let us know. And that's what happens when you train people like that, folks. What you then get is exactly what happened here. And that is, notice that Hopkins nor EJEC even called the principal. They never called the liaison officer. They never called the Oakland County Sheriff Department, who has a 911 squad ready to assess threats like this. Never did any of that. And that's because they were trained not to. We believe those are the grounds for constitutional deprivations that are the essence and the backbone of our federal case.
We've made Joe Suave and Craig Schilling available to you folks today. Obviously, there's an incredible public interest in this case to get to the bottom of everyone accountable. That means, of course, all three Crumblies, but also the entire school personnel and how it worked or not through their system. So we're doing that today, and I'm going to turn this over to these folks. I've asked them if they wanted to share some thoughts with you folks to do so. When we get done with that, I'm going to turn this over to you folks, and you get to ask some questions, and then we'll be done. And I'm going to ask the same thing I asked last time on behalf of my other clients, but now on behalf of Jill and Craig. Please then respect their privacy. We're doing our best to allow you access to them at the appropriate time to ask certain questions, but understand, obviously, this is an incredibly just impossible situation for them. And that after today, obviously go through near perfect media, go through my offices. You want to have contact with folks, always come to us. Do not skip over and try to contact them directly. I can assure you that will not happen. And if it does happen, that will be the last time that you ever interview a Johnson Law client. But you folks are great. I don't think you'll do that, other than one person that tried that last time. So in any event, Jill, would you like to share some thoughts, please?
Absolutely. Thank you. Good morning, and thank you all for being here. This is very hard, so I appreciate your patience. Our son Justin was such a dynamic child. He was funny, handsome, smart, loving, classy, and kind. He was an old soul, so very wise and empathic. Justin motivated and uplifted all who knew him, both children and adults alike. He was awarded top scholar, National Honor Society Gold Cord and Stole, IB Diploma, and Seal of Biliteracy. He also won the Oxford Cup, which he wasn't there to accept, and his siblings had to accept it in his absence. He had an extremely bright future in store for him. Justin's entire family, all of his many close friends, all of his aunts, his uncles, his cousins of various ages, we're beyond heartbroken. We're traumatized, and we're devastated, and we are not okay. It's been 174 days since he was murdered, and it feels like it was just last week. For me, there will never be healing. There will only be coping. I will never be the same. A third of my very being, my heart and soul, was violently ripped away from me. Justin's siblings will have to live the rest of their lives without him. Birthdays, weddings, holidays, he won't be there. Everything is so hard for us right now. It's like pushing through mud. Justin has a newborn baby cousin that he will never meet. One of our little cousins, Lily, is only 7 years old, and she's such a smart, bright young girl. She's old enough to understand that Justin was violently murdered, and she's old enough to feel that trauma. She was afraid to go to her school after Justin was murdered, saying, "What if a bad man shoots me on the bus?" My heart breaks for Justin's grandparents on both sides, as the pain and grief is almost too much. It's a very heavy cross that we will all have to bear. It will take generations to even soften the pain for us. Justin's final moments were spent protecting Keegan. No 17-year-old should be put in that position. Justin also saved 5 lives through his gift of life with organ donation. Justin, Hannah, Tate, and Madison deserve justice. They deserve full transparency and full accountability. And I 100% promise you, if Justin had been spared through this tragedy, he would be fighting for all that, and he would be a huge advocate for change because that's who he was. So thank you.
It's phenomenal. Thank you, Jill. Craig?
Thank you, Ven. Good morning, ladies and gentlemen of the press. Thank you for coming. As we know, it's been about 6 months since Justin was taken from us. During this time, I chose to lay low and grieve and mourn and cry and heal. And just try to put myself together again. Because let me tell you, when the reality of something like this really hits you, it feels like an explosion in your mind. And the shock of it just cripples you to a point that you can barely function and really don't even care to. But eventually, there does come a point when you start looking for yourself again. And while you're putting your pieces back together, you start to realize that you can have rational thoughts, that you can accomplish normal things. And you start believing that maybe you can actually continue living even though it hurts so bad. But also during this time, while you're looking for your pieces, you're assessing the damage that has been done. And you can't help but notice that seemingly around every corner you turn to look, you find yourself at the edge of a gaping hole that has been left in your life. What do I do now? There's only one of 1,000 questions that just flood your mind and consume your thoughts for hours on end, through sleepless nights and the darkest of days. How, why, who, what, where? They're all there, lined up one after another. Now we know the answers to some of these questions. They are obvious and pretty cut and dry. But I have recently found out from my lawyer that some of our questions may actually never get answered. And I ask why. He simply explains to me how there are laws that exist that actually protect certain individuals from being required to answer certain questions. He calls it governmental immunity. From his explanation, I gathered that he was basically saying that as long as you work for the government, you can completely screw up the job that the taxpayers pay for and trust you to do, and you'll never have to answer for your actions or lack thereof, and you'll never be held accountable. I ask, how is this possible that a law like this even exists? How is it possible? How could it ever be considered fair and equitable for everyone? How can anyone in my position possibly navigate through or around or across such a gaping hole without having all their questions answered? We deserve to know what the hell went wrong for something like this to happen. Because identifying the problem is the first step to finding a solution. And a proper solution can help prevent something like this from ever happening again. And this is why we are here. We seek the truth so that we may achieve some level of closure, and that we'll be able to actually begin to heal ourselves. Thank you.
Thank you, folks. Before I turn over to questions, tell you folks 2 more updates. This Wednesday in Oakland County Circuit Court, the parties in our state court action will be arguing a number of motions that I know I've got a lot of press attention. You got folks have been asking me. So the update is this: on Wednesday, as of right now, I believe at 8:30 in Oakland County before Judge Chabot, we'll be arguing a number of motions where we are asking the court to enter an order to compel or force the Oakland County Sheriff to actually give us their investigation file, which they have not yet. to force the school district to actually respond to a subpoena and give us all of the information that they have relative to this entire situation, including the videotape and the surveillance camera videos that obviously will give a great insight into a number of issues that will be a part of all of these lawsuits. So that'll be a very big day. And we also have, as part of governmental immunity, in the state court case, the individual folks, because again, I can't sue the school district there, Ms. Fine, Mr. Hopkins, Mr. Ejak, Ms. Kubina, Ms. Morgan, Ms. Karpinski, they have each filed a motion for summary disposition, which therefore means they're asking Judge Chabot, throw me out of the case because of governmental immunity. Now ask yourself this. These folks haven't even seen the effects yet of the investigation. They haven't seen anything, not that they would want to see some of the stuff, but they have the right to see it if they choose to, and they certainly have the right to have their lawyers see it so that I can advise them of what it shows. That's my job, and I've been precluded from doing my job thus far. But despite that, these governmental employees have said, governmental immunity, you can't sue us for this, and they're asking Judge Chabot to throw the case out of court. That hearing, as of right now, is scheduled in July, and we will, Mr. Chris Desmond of our office is already working on our response, along with Jeff Stewart and Ken Carr and I and our entire teams. But ultimately, we'll be arguing that as of right now in July. That will obviously be an open court hearing date. And in the event that those governmental officials lose, in other words, if Judge Chabot rules against them, what we certainly hope she does, doesn't mean we win. It simply means the case goes on its path to trial. But the thing you need to know about governmental immunity, folks, because I've already told my clients here, if they lose that, they then have an automatic right of appeal to the Michigan Court of Appeals, which will be an automatic stay or closing down of the proceedings for the next year to year and a half. A year or year and a half, because unlike a normal citizen who does not have an automatic right to go to the Michigan Court of Appeals after such a motion is denied, governmental employees do. So it delays these proceedings, hence the reason why they've done it. And I will tell you, in 36 years of practice, the only area of law where folks filed such motions like this from the very beginning is when they represent governmental employees to delay these proceedings even longer. So that is your update on that. Justin, Alex, I want to turn it over for questions. Thank you, sir.
Thank you all for being here. Simon from Channel 7. There's been a lot of discussion about having independent review, third-party review. Like to know your thoughts on that, given the fact that you've already assessed here where a lot of the wrongdoing you're alleging took place, and the school seems to have a good understanding of what exactly went on that day of that tragedy. Your thoughts there?
Simon, absolutely. Not just a school, a business, Channel 7, Ven Johnson Law. God forbid some horrible tragedy happened there. A reasonable and responsible business owner, school district, company, person would do an investigation to try to figure out and get to the bottom what went wrong. Was there something that we did that we could have done better? Did we somehow contribute? Did we not? All of that should have been done from the very beginning. And as you know, Attorney General Nessel could not be more obvious in saying, hello, Oxford, use me. I'll do it for free. You don't need to pay me. I'll do it. No, no, no. Then they go back and forth as to whether they're going to do it, how they're going to do it. As you know, the school board switched in the last week, 180 degrees. Now they're going to do it, because remember, they were going to wait till after the criminal and civil cases were done. Translation, once you all figured out, and as you know, because we held a press conference to make sure you all knew, you're talking about 5 years down the road, probably. Why would you investigate then? So absolute ridiculous that they've waited I think that's what Jill's talking about. I'll turn it over to her in a minute on transparency. I know Craig feels the same way. Absolutely should have been done and should have been shared. Let me give you two examples of what I'm talking about. Their graphic, Michigan State and Nassar, sex abuse cases. Michigan State turned it over to a law firm that came in from out of state and investigated, did not share the results. And if you recall, for the year after that, every single one of those brave young lady, I had one man as well on my as part of our clients, but every one of those young ladies came forward and talked about what? The lack of transparency of doing that. What happened at U of M and the Anderson sex abuse cases? U of M hires an outside law firm to come in and investigate, and U of M learned from that mistake. And they published that report and shared it with all of us, while obviously we're part of that litigation as well, while it's pending, knowing full well, Simon, by doing so, since the findings were highly critical of U of M, it could hurt. But they did it because they're a public entity and they wanted to be transparent. I give them total credit for that. And then you compare both of those with Oxford, and they haven't even done an investigation yet. It's over 6 months. So there's without precedent. This is no such thing I've ever seen in my life of what they've done here. And now, whatever they're going to end up doing it, who cares at this point? It'll have no effect, really, I don't think, on the civil case. Karen McDonald, the day after our press conference where we talked about how this would be a 3 to 5 year delay, what are you waiting for, Oxford? Don't wait. Karen McDonald, to her credit, put out, and I know you saw the statement, that, oh, it won't screw up the criminal case, go ahead and do it. I mean, come on, man. Honestly, it's offensive. And remember, these folks have kids in this district. What would you like them to do and feel?
Just to reiterate, also, you mentioned this Wednesday, you're going to appear in person to argue for release of police reports.
Yes.
And videos.
Yes.
In court in Oakland County.
Yes. And then Judge Chabot will obviously, we anticipate, will make rulings. And there are various viewpoints that will be aired, and they should be. I understand. And again, total respect for Karen McDonald, who I know extremely well, great prosecutor, and I applaud, as these folks do, the job she's done. Thank you. But yes, we're going to have some differing viewpoints on certain topics, which should be aired. Judge is going to hear them and ultimately make a ruling, we hope, on Wednesday. Thank you, Sean. Good to see you, man.
WDIV Channel 4.
Yes, sir.
What files and videos are you looking to obtain from the Sheriff's Department?
All of them. I don't know what I don't have, but I know the school district has them on the outside of the school and on the inside of the school. And as part of being a lawyer on behalf of these folks and other folks, I need to know, not just rely on what the police report says, which I haven't been given yet either, as to what happened at given times. But a lot of that is going to have to do with a number of items in this case. Okay. So when there's interaction between Ethan Crumley and the school folks, some of that is going to show on the video about when they're walking down the hall, what office they went in, how long before they came out. All of that information I need to have for my clients that I don't have yet. So all of it is what we think we should get. And then the other folks will say what they have to say, and the judge will make a ruling on that. Dr. Langton.
Mr. Johnson, good to see you again.
Good to see you, sir.
Jill, Craig, I'm Charlie Langton, WWBJ and Fox 2 News. I don't know how you do it. I applaud you. It's got to be very difficult. My question has nothing to do with the law. Ven will handle it. And please don't take this the wrong way. How much of that video do you really want to see? Do you need it for closure? Do you not want to see it? And I'm just curious. Forget the law. Just what's in your heart right now?
Let me answer for me first, and then I will be happy to ask the folks to respond, Charlie. We don't know because we don't have it. So the answer is, like in any other case in 36 years of practice, as you have as well, I have to see the evidence. I'm not stupid. I'm not going to show my clients something that they don't want to see. For example, I can't even get their child's autopsy report from the Oakland County Medical Examiner because they're claiming now, even though I got the autopsy report from Buck on behalf of Tate Muir, they're blocking me from getting these folks' child's autopsy that they're entitled to because there's an ongoing investigation. All right, that's ridiculous. And that's Oakland County. So I'm not blaming Dr. Dragovic in particular. I know what's going on. But the fact of the matter is I need to get all of the evidence. I will then share, much like I had to with the Muir family. How much do you want to know about the autopsy report? Well, they attended their son's funeral, so they already knew way too much anyway. Okay, but I need to, how much do you want to hear about it? Do you want to hear what's important and what may not be important? Do you want to hear, and then I can assess what they want to do. And do any of these folks want to sit down and watch a stem to stern? My guess is probably not, but it's my job and my obligation to get that evidence and then share. And then these folks make what we call in the law an informed decision about what they do want to see and they don't want to see today. And then take us how many years down the line to trial? It's going to be in the courtroom, y'all. You all know that. It's going to be, it has to be. It's part of the proofs. So, and then if the folks choose to leave the courtroom, I'll give them advance notice like I do in any case. And if they choose to leave, they'll leave and then come back with a son or what have you. But Jill, would you like to respond just in general to that question as a mom? And
none of this is easy. I mean, I don't see how the video is going to be worse than arriving at the hospital. So, you know, I personally watch every court appearance. I feel somewhat of a comfort knowing the details. Blocking it out doesn't help me in any way, you know. Going through this, I feel like it's a way to honor Justin's legacy. He deserves me to be strong and to do what I have to do. And there's certain days that I can't get out of bed and I can't watch anything, but I can go back on YouTube later and get myself caught up. So for me personally, that kind of ties into full disclosure from the school. When you don't know anything, what do you do with your brain? How do you function? So it's very difficult. It's beyond difficult. I don't know how I'm doing this. It's by the grace of God. It's by the prayers. It's the love and support that we receive. But for me personally, the details help me feel a sense of control. Things aren't being, hidden from me. And again, as Ven stated, you can pick and choose the appropriate time that you want to view certain things or really, get into certain details. So for me, it's helpful. And I need to know it. I don't know how his soul can rest if the truth isn't out for all these kids. And I think people in the community feel similar. Months and months and months of no answers. It's like insult to injury. So for me, it helps me to know everything.
thank you. Greg?
I'm a little bit different when it comes to intimate details. It's basically cut and dry what has happened to my son, and knowing that I'll never have him around again. I don't feel the need to know or see everything that happened. For the most part, I've limited my exposure to the social media and the coverage of the case, mostly for myself to be able to try and heal or collect my thoughts and process the loss. I know that I fully trust that my lawyer will be able to advise me the correct proceedings and help me along this path. He's the one that needs to know all the intimate details. I know that my son is gone, and for me, I will personally won't be able to achieve that level of closure until I know that my questions are being answered honestly, and all of them. I don't want to leave any rock unturned. I know that the delicate nature of the subject and affects so many. It's really a process. The next few years are going to be pretty wild, I'm sure. Just the last 6 months have been unbelievably crazy, but I'm still here. I'm still fighting. I'm still trying to, get to the bottom of things. So that's what I'd like.
Hi,
Thank you, John.
Lily Altavino with the Detroit Press. Thank you both for being here. And Ben, I guess it's like a procedural question. I did a search of the board docs policy book that Oxford has.
Right?
And I can't find the suicide intervention process up anymore. Do you think they had like an indication that you guys were looking at this, or?
I can't wait to find out.
Okay.
I mean, this document obviously exists. It says what it says. I don't think somebody went online and created it. And if they did, what a horrible thing, right? But the answer is until the school produces it, which is what they're trying to not do, right? They withhold information. And you guys think about society in general, right? When you want to get away with something bad, you try to hide it. That way no one knows what really happened, and certain folks or you can't be held accountable. So we will get to the bottom of it. I assure you, whether it's state court, federal court, or I certainly hope both, we're going to find out, and I'm happy to tell you about the whole thing. But I do know they had a suicide intervention program. I do know that there are previous issues that we will be fighting about on Wednesday about previous suicides and previous suicides that either did occur or were prevented and so forth, what the program was, et cetera. But the most important thing to me about your question is these folks clearly were not adequately trained to do what they are required to do under Michigan law, and that is to report to Child Protective Services to figure out what's going on so this person can be intervened, can be interviewed, can be assessed, and they can be protected and others can be protected from them.
I just have one more question for Craig and Jill. It's graduation season. It's a really special season. Justin was one of the top students in his class. What did you hope for in this season?
I'm sorry, I'm not sure if I understand. What do we hope for?
Yeah, what had you hoped for Justin for graduation and for his future?
Oh my goodness, he had unlimited potential. He was planning to attend Oakland University and study business. He was a natural salesman. Everyone loved him, adored him. Planning graduation parties this summer, big family parties. It was an open opportunities for him. He wanted to start, maybe even get a real estate license and start flipping houses with his friends. What 17-year-old has all this in their mind already? I want to be an independent business owner. So it's, all those things.
Yes, you could only, you only wish that they will have what you had when you graduated, the fun times with your friends, the parties. But he won't get that.
I've obviously been very critical of Oxford Community Schools, in particular the high school, on a number of topics. But on behalf of Jill and Craig, I do want to publicly thank them. I thought it was a very classy thing that they did, and they gave him the Oxford Cup, which I interpreted it as Senior of the Year.
Yeah. Yes, and it's really, and he would have won that regardless, but based on his academics, well-rounded, volunteering, so it's just even says on the award, most distinguished student. So he was known throughout the school by students and teachers and liked and just beloved. And all these stories came out, which were beautiful, things that we didn't even know because he never bragged about it. So when you've got teachers and students saying, Justin was my first friend when I moved to Oxford. Teachers saying he was my, first friend when I transferred. He impacted so many people. In 17 short years, and never bragged about it, worked tirelessly. His grades were outstanding. He was almost too good for this world, and he made me a better person. So the potential that he could have changed this world, he would have been such a loving father. Children loved him. So it's, You know, if he was a C student and he was murdered, that doesn't make it any less tragic, because no child deserves to be murdered like this, and no family deserves to go through this tragedy. And it just should have never happened. So I kind of diverted. I apologize.
No, you answered it perfectly. It was a great answer.
Ben, are you able to say, is this document, just to make clear, is this a statewide policy or a policy unique to the school? And how difficult was it to get this? Are you able to say how you got it?
No. In a word, Simon, no. One of the things that I love about the coverage that you folks very candidly have done, and I appreciate it very much. We get reached out to, not just me, but the other attorneys on behalf of the families. We've had obviously discussions, and I applaud them, and I appreciate that they are as open with each other as all of us as we have been. But we get contacted by folks that know things and have talked to people and have inside information. I don't say every day, but all the time. And this is something that I've had now for a couple of months. But I know it was in effect. I already know that as part of the defense, if you will, relative to the teachers and so forth, the teachers are going to say, all we do is follow that. And if we messed up, and the school district would have told us, and they never told us that we screwed up. Well, like we all know, to do an internal investigation means nothing if you're not really doing it in earnest and doing it to look to see if things can get better. And what you cannot do is violate Michigan law. And that to me would be the number one thing. If you think, I wouldn't have it on just the severe stuff, it should be at the top. If you believe a child is acting in a certain way because of abuse, neglect in the home, call CPS pursuant to your mandatory mandate. You're required to, and let them figure it out.
Thank you.
You're welcome.
Question from Jonathan Yinger, CBS Flint. For Mr. Johnson, if in fact the named teachers did as they were trained, are they off the hook, so to speak, for not reporting this to CPS or calling 911?
Thank you, Jonathan. And I'm going to ask you to return to the section that I put up and talked about before. Michigan Compiled Law 722.623. A notification to the person in charge of a school does not relieve the member of the staff or school of the obligation of reporting to the department, meaning the Child Protective Services, as required by this section. So to us, if these folks who are clearly going to take the position that they were trained teachers only to report to counselors, or only report to Mr. Ejak or whoever internally, that's not enough. And my question to you would be, if you had a child sitting next to you or next to your child that were drawing pictures of guns, dead bodies with blood squirting out, with ammunition, and I'm not for this world, my life sucks, you name it, things like that, in 2 different days, looking at live ammunition rounds for automatic firearms, what would you do? And the answer is, you would report to the authorities, even though you're not a mandatory reporter necessarily. Mandatory reporters must report. So answer your question directly. The teachers absolutely are still liable as it relates to this particular section.
Follow up from Jonathan. Knowing that the summary motion being heard in July could drag this on another 1.5 years, is removing the named parties a strategy for moving your actions along?
Removing the named parties. We have not removed any names. In fact, we're the ones that broke the names of the teachers first and put them in the lawsuit. So I apologize, Jonathan. I don't understand your question. Ask again if you will, please. Charlie?
Then I'm just curious, assume there is a violation of this statute. Is the remedy a violation? Does that remove the governmental immunity claim? I don't want to get too technical, but
see, he's such a lawyer. Here's the answer, Charlie. Sorry for the rest of you in the room, Law School 101. This is a separate and distinct section of Michigan compiled laws. And by naming school teachers, administrators, and if you look on some of the other police officers, by definition, who do all those people work for, everybody? The answer is often public. So when the Michigan compiled laws passed this, I think it's in the 60s, early 70s, effective 1975. Charlie Langton was even a young man back then. But the answer is they knew these were governmental employees. If they wanted to give them governmental immunity, it should have been in this statute. However, there is a current Michigan, I won't say current, I think it's a 2011 case, Chris Desmond? 2012, I was off a year. Give me a break, Desmond. Thank you, sir. 2012 case that a Court of Appeals panel ruled that even though this is a separate and distinct, and by the way, as you guys know, I read this to you last time, in this very law, it says that a failure to report can be something to come or can lead to criminal charges against the person or civil liability. So they create a cause of action in this section, which I know you know what that means, Charlie. But the Court of Appeals panel sadly said, oh no, it doesn't say gross negligence, the proximate cause, but that's what it meant. It does not. And I can tell you in our pleadings in front of Judge Chabot, we've already, Desmond has done a great job in the briefs. We're attacking that ruling. That's wrong. And that's one of the things that we will be seeking. If any of these folks get dismissed on appeal, or if it's all denied and they do appeal like we think they will, we're going to be filing a motion to set aside that appeal for various reasons, and that's one of them. If that makes any sense. Sorry that I'm just talking to you probably, but no, it's good. It's a very important legal distinction that what happens here is the Child Protection Act, y'all, was designed to do what? Protect children. And who has more exposure to children than the folks at school? So this is an incredibly important, and I know talking with Craig and Jill, having this never happen to another person's child is foremost. Understanding what happens since they don't, getting full transparency, and then exposing that, calling attention to it, coming up with better processes so no one ever has to go through this again. It's exactly what these folks are doing. And on this very point, Charlie, that you raised, thank you for the question.
This will be the last question. Clarification from Jonathan Yinger. Clarification, if you remove these parties, the motion being heard in July and the potential of dragging this out, could that go away?
Okay, but I guess, Jonathan, I apologize. See, that's what happens when you're asking questions from a guy from Saginaw and you're from Flint. Hopefully you're laughing. I'm not removing the parties. I think what you're asking me is, if judge dismisses this case as to all these parties, what does it do? And the answer is, then we, as a matter of law, would have lost the case as it pertains to those folks. And then we would be appealing. So I'm not, we're not removing any parties. The other thing, maybe to try to read your mind over the online, those parties we did not mention in the federal court, because under federal law, we believe that the folks who are responsible is Oxford Community Schools, who are the ones that put these things in place. And as part of how these teachers, if you will, responded to that, also are federal claims, but that's kind of the difference between federal and state. So I hope I somehow stumbled across your answer. Thank you. Thank you, folks.